clerk will open the court.
Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
The court's ready to hear argument. In 19-243 and 19-244, Wagner versus Apache Corporation, both from Tarrant County and the Second Court of Appeals District.
May it please the court, Mr. Keltner will present argument for petitioners. Petitioners have reserved 5 minutes for rebuttal.
Thank you, and may it please the court. While I represent Wagner Oil and Brian Wagner, Bill Kirkman, who represents trade, and also Wagner Cochran, asked me to tell you that he's asked me to make the argument for trade. Wagner Cochran has been discharged in bankruptcy, I think, as this court knows from previous filings. This court is certainly no stranger to arbitration disputes, but the Court of Appeals opinion presents a new wrinkle this court needs to address. I'm going to address three primary issues. First, the Court of Appeals dangerously expanded the presumption in favor of arbitration to overcome the parties' express carve-out of claims from arbitration. Second, the Court of Appeals accepted Apache's unexpressed intent about the indemnity obligation to improperly use the merits of the dispute to determine the method of resolution. This is something that the United States Supreme Court says can't be done. Finally, the Court of Appeals based its decision that the non-signatories were not bound to an arbitration agreement to which they were neither signatories nor parties on a case law that this court specifically rejected and reversed in a subsequent opinion. And we'll discuss that in some detail. Let me turn to arbitrability first. In three cases, the Supreme Court of the United States has made clear that the presumption in favor of arbitration does not overcome a carve-out from arbitration that the parties have agreed to carve out. And in those decisions are Volt from Chief Justice Rehnquist in 1989, who said under the FAA, parties are clear and allowed to carve out things from arbitration, and there is no prohibition. And in fact, he points out actually that the FAA encourages agreement among parties, and those must be enforced. First Options of Chicago in 1995 followed suit, and finally Granite Rock by Justice Thomas in 2010 made the same ruling and said the presumption can never overcome and never overrule the principle that a court may not submit to arbitration or may not submit to arbitration those disputes in which the parties have specifically agreed to commit. Fifth Circuit.
What do the courts say about if the carve-out scope is ambiguous? Does the presumption apply in that? And I understand you say it's not, but
yes,
in a case where it is, what do the courts say about how the presumption operates?
The presumption would come into play, I must admit, at that point, if it was determined to be ambiguous and less than clear. I think the presumption might play a role. We don't believe it plays a role here. But I'm going to point out a case to you that's important on that, and it's the Archer and White case from the Fifth Circuit Judge Higginbotham in 2019. Similar carve-out, almost identical to what we have here, except it used the term except rather than notwithstanding. In that case, the carve-out was far less clear because the issue was the carve-out took out claims involving injunctive relief. But the antitrust case that was brought in that case both sought injunctive relief and damages. So the question was, does the carve-out extend to the damage claim as well? Judge Higginbotham said it did and said that was clear, even though the word damages were never mentioned in the exclusion and only injunctions were. That case is far less clear than the case we have, and therefore I don't think that we have the ambiguity that would give us problems. This court certainly agreed that the carve-outs would be considered and that arbitrations are matters of contract. Justice Guzman in Jody James Farm made that ruling several places in that opinion. By the way, citing Chief Justice Rehnquist's opinion in Volt for that exact proposition, and also first options as well. The Court of Appeals, however, went another way, and it even characterized the presumption in favor of arbitration and accepted Apache's view for it. And here's what they said, and this is a quote from the opinion, it is not me, that the presumption in favor of arbitration is so compelling that the arbitration should be imposed because it can't be said with positive assurance that the exception applied. Really, that's not the way the Supreme Court went at it in Volt nor in Granite Rock, and certainly contrary to what happened in Apache and White, which again was a case that was far less clear than our carve-out. And again, the question of whether damage claims were covered in Archer and White is far less clear than whether there was a carve-out of third-party claims in this case. But the second evil of the Court of Appeals opinion, I don't think it was intentional. Please don't get me wrong.
Before we get to that, Mr. Keltner, you were, and certainly we do need to look, as you say, at the language of the contract. So doing that, why doesn't specifically the notwithstanding clause? It says that if there's a third-party action, the buyer and seller shall not be subject to mandatory arbitration. But couldn't they still go to arbitration if they wanted to? I noticed one place in your brief you said that was a prohibition on arbitration, but it seems to me it's saying that the buyer and seller shall not be subject to mandatory arbitration. Don't we have to give meaning to that?
Yes, you do, Your Honor, and you're precisely right. To the extent that our brief suggests that the parties couldn't voluntarily go, that is an incorrect reading of this provision. And you're correct. I'm sorry.
No, and so with that being said, is it a reasonable reading of this provision that that basically it's giving the parties two options, and if there's a third party action, one option is to go to arbitration, which is not mandatory, but it is available, and the other option is to assert their claims in a third party action, which they're entitled to do but not required to do. So they get to choose between those two options.
No, Your Honor, I don't think it is. Here's why. Look at the term that you mentioned up front, notwithstanding. This court has interpreted that phrase in both El Paso Field Services and again in UT versus Garner of saying when notwithstanding is used, everything above does not count, and that is the broad agreement to arbitrate, and everything below does. We don't think that there's any reading of the carve-out that would suggest that you have to assert a third-party claim in order to avoid arbitration. After all, the parties used permissive language, shall be entitled. It doesn't require to be the parties to do that. It doesn't require a cross action in the third-party claim to avoid arbitration. Nothing suggests that, and the idea that would be the result, I think, is contradicted by the use of the term notwithstanding. And the arguments that the other side makes on that, I think, are unavailing. First, they say, well, you're treating the last phrase of the clause in such third-party action as surplusage. That's not true. I'll explain that in a second. But really, in Ray Davenport gives us a good map on how to deal with that. That was a 2017 case by Justice Willett, in which he held that even if you're dealing with a surplusage issue, you can't change other words by that kind, by surplusage. And he didn't in that case. In that case, it was actually lawyers' attorney fees dispute, and they were trying to infer a positive from a negative. And the court said, no, can't do that. And the surplusage argument wouldn't work to do it. The other side also says, Apache says, well, it's a dependent restrictive phrase, and therefore that made what is permissive, mandatory. That's also not true. The case they cite is the Steumann Ranches versus Double M Ranch. And in that case, the court did apply the restrictive dependent phrase and said, look, it applies to one thing or another. It doesn't change the wording of the document. And Chief Justice Wright from the Eastland Court of Appeals decision is clear on that issue. The other thing that Apache says about this is somehow this will moot the obligation to arbitrate. That's not true under the facts of this case. Let me explain. The truth of the matter, there are still obligations that survive closing, and those could certainly be arbitrated. Look at 9.2 and 11.8 of the PSA, and that is clear. But additionally, we know that the majority of environmental cases are not brought by parties, but are regulatory issues brought by state agencies and the federal government. Those would not give rise to a cross-claim, and those are certainly arbitrable, and we've never said to the contrary. Now,
I don't want to waste your time making you go back over what you've already said, but I'm really having a hard time following that. And I think this is such an important issue in this case, the language of this contract. So I think I understand what you just said, this language does not mean, but can you walk me through the language and tell us what you think it does mean? I mean, if it doesn't mean what you say, what they say it means, I'm having a hard time figuring out what it does mean.
Your Honor, I'm certainly glad to do that. If you look at my oral argument handout, tab 1, we have prepared that for you. And by the way, it's interesting that Apache has done the same thing, but we concentrate on slightly different things. And I'm going to go down that handout if you don't mind. And here it goes. Notwithstanding the above, and above is the previous sentence, broad sentence requiring arbitration. Notwithstanding the above, in the event a third party brings an action against Wagner Oil or Apache concerning the assets, and the assets are what was purchased in the agreement, there's no doubt about that, Wagner Oil and Apache shall not be subject to mandatory arbitration under this section. Now, I'll admit, if you cease the sentence there, obviously there is no mandatory arbitration. But if you go forward and then say, and Wagner Oil and Apache shall each be entitled to assert their respective claims, if any, against each other in the third party action, it doesn't require it. What it says, you may if you want, but if there is a third party action filed, arbitration is off the table. You have the option of asserting it as a cross claim as you ordinarily would, but that's, I believe, what it means. You can, but you do not have to.
So, Mr. Keltner, do you contend that if the indemnity claim ripened after the underlying litigation, that and one side or the other chose to bring the indemnity claim, it would have to be brought in court? It could not ever be brought in arbitration? Or are you saying that if you don't bring a third party action, you're just out of luck? You can't sue in court and you can't demand arbitration. Are you basically saying this is a limiting clause that says that either side must bring their cross claim or their third party claim in the underlying litigation?
Question, and the answer is no. We don't claim that you had to bring it or lose it. We've never made that complaint at all, and that was clear actually in the hearing in front of Judge Wallach, who basically found that the carve out existed. We agree that it's not you lose it, you make it in the cross claim or you lose it. They have an opportunity to sue us, and actually that's I think their interpretation as well. I've got just a few minutes. Let me address one other thing. We did say the court did indulge at Apache's invitation to look at the merits in order to decide the issue of the method of resolution. The court went so far as to say that Apache wanted to walk away. Well, that's nowhere in the agreement, and that impacted the court's decision. If you look at page 9 and 10 of the decision, you'll say that. That's improper. Granite Rock cites a number of United States Supreme Court holdings that looking at the merits to resolve the method of resolution is always improper. And this court has not addressed that, and I would urge the court to do it. On the non-signatory beneficiaries or assignees, I will address just a couple of things. First off, there is no direct line that would tie them to this. I will admit that the Apache, the Wagner assignment adopts the Apache assignments, which does bind to the PSA, but there's not the direct line you see in the cases that Apache has cited.
But Mr. Keltner, I took you all to concede, your side to concede that you would owe at least the proportionate part of the divisible obligations.
Your Honor, what we're saying is that there would be a divisible obligation that might be impacted. I don't know that they actually get there under the court.
Well, but what I'm asking though is if you owe the divisible obligations, then this chain of assignments incorporating each other by reference has to work, or you wouldn't owe anything at all.
No, our point on the divisible issue, Your Honor, is that there are some obligations that are not divisible under the contract, and we certainly could not. The non-signatory assignees certainly could not have assumed those. Does that make sense? We do not concede that we absolutely do. I see my time's expired.
Any other questions? Thank you, Mr. Keltner. We'll hear from the respondent.
May it please the court, Ms. Robinson will present argument for respondent.
Good morning, Your Honors. May it please the court. Wagner's argument in its brief to this court has been that once a third party files a litigation against Apache or Wagner relating to the assets, that mandatory arbitration is no longer available for claims arising out of that third party action. The problem with Wagner's argument is that that language does not appear in section 1112. If you'll please turn to page 4 of our bench book.
Ms. Robinson, before you go through that exhibit, do you contend the provision or the agreement is ambiguous in any respect?
We don't believe it's ambiguous, Your Honor, but we believe our interpretation is the only reasonable interpretation, and obviously I'll go through that, but if it were ambiguous, because this is an issue relating to scope and not an issue relating to whether or not an agreement exists, because there is no dispute between the parties that as between Wagner Oil Company and Apache, there is a valid and binding arbitration agreement. So this dispute over what this sentence says relates solely to scope. And this court has held that issues of scope must be, if there's an ambiguity, must be determined in favor of arbitration, and exceptions from the scope have to be construed narrowly.
I thought I understood what your position would be. I just wanted to just make sure that I understood that neither party claims we have an ambiguity here. Thank you.
Correct, neither party does. So if you look at this language, what Wagner wants it to say to make its argument more appealing is that this language, the operative language, ends at 2. And as Wagner said in its own brief for rehearing, it said that the language beginning at 2 doesn't really add anything. What it said is that it merely, and I quote, is a representation of the reality of the situation that is created by the preceding language. So in order to make Wagner's argument more appealing, what they want us to say is, notwithstanding the above, in the event a third party brings an action against a buyer or seller concerning this agreement or the assets or transactions contemplated herein, buyer and seller shall not be subject to mandatory arbitration under this section for claims arising out of that third party action. And you have to insert that phrase, for claims arising out of that third party action, because it's not there. If you read this sentence according to Wagner's interpretation, what really happens is that when a third party files a claim, and make no mistake, the parties absolutely anticipated that environmental lawsuits were probable, as their extensive language about that in the contract shows. When a third party files one of these predictable actions, then under Wagner's reading, what in fact happens is that there is no more mandatory arbitration between Wagner and Apache for any claim, whether or not it's related to that third party action ever. And that reading is absolutely absurd. And Wagner knows it's absurd. And that's why they've changed it and inserted that phrase, in such third party action, into their argument. These parties not—
Ms. Robinson, why doesn't the CA's interpretation write out the term notwithstanding language? I'm not understanding what you want us to do with that.
Oh, absolutely. It does not write it out, Your Honor. The preceding language is any disputes arising out of, and that's the broad arbitration provision. Notwithstanding the above says, here is an exception to the scope of our arbitration provision. Now, this is really different from the El Paso language that that Mr. Keltner referred to, because in that case, actually, what the language said was notwithstanding anything else in this contract, which is not actually what this says. And what they use that for is to say, so you can ignore the fact that there are 5 single-space pages about arbitration procedures, and you can ignore the fact that indemnity was clearly an issue that was high in the parties' minds. You can ignore all that according to Wagner because of the word notwithstanding. Now, this is not the same language as was in El Paso. What it's saying is, notwithstanding the fact that we have a broad arbitration provision, here is one narrow exception. And Wagner's right when in its briefing says that everything after 2 doesn't really add anything to the meaning of this sentence. Under Wagner's interpretation, it really doesn't. Now, Justice Bland, I'm so glad that you asked the question that you did, because in fact, in their petition, Wagner does take the position that the only time Apache could have asserted its indemnity claim was in that third-party action. And you can find that in the record. I believe their petition begins at page 5 of the record, and the parties cite to the record in the 132. You know, there was 2 records in the case, but the 132 action in Fort Worth is the one the parties cite to. I believe that where they say that we can't ever sue them for indemnity is actually on page 8, but that is also an absurd reading of this provision. Now, there's another way to read this provision that is not absurd, and it does take into consideration grammar. And that is to look at the language marked at 1 and 2 in our bench book, and note that those phrases are conjoined by an and. Buyer and seller shall not be subject to mandatory arbitration under this section, and buyer or seller shall each be entitled to assert their respective claims, if any, against each other. And then it is followed by the restrictive clause in such third-party action. Now, we go into our brief many examples at pages 36 and 37 of restrictive and non-restrictive clauses. But non-restrictive clauses are ones that are set off by commas because they are parenthetical. You can lift that information out of the sentence, and it doesn't fundamentally alter the meaning of the sentence. And we have an example of that right here in this sentence where it says their respective claims, comma, if any, comma. The if any is a non-restrictive clause. It's parenthetical. It's set off by commas. You could lift it out, and the fundamental meaning of the sentence does not change. But in such third-party action is a restrictive clause. It has to change the meaning of the sentence that it is part of. And here, not only do we have that restrictive clause in such third-party action that modifies the language that comes before it, but the sentence actually refers to third-party actions twice. They bookend the sentence. In the event a third party brings an action, that's the beginning. In the end, in such third-party action, that is what this clause applies to. Everything has meaning. Buyer and seller shall not be subject to mandatory arbitration under this section in such third-party action. Buyer or seller shall each be entitled to assert their respective claims against each other in such third-party action. Now, I understand that some of you may be asking yourselves, is this sentence ambiguous? We actually believe that our reading, because it follows the rules of grammar, because it doesn't insert any language that isn't there, because it gives meaning to all the language that is there, our reading is the only reasonable interpretation. But that being said, again, there is no dispute that there is a valid and binding arbitration agreement between Wagner Oil Company and Apache, and I'll talk about the non-signatories in a moment. Oh, Your Honor? Justice Boyd?
Yes, I do have a question, Ms. Robinson. So do you concede that Wagner could bring this exact same declaratory judgment claim, seeking a declaration that they do not owe indemnity against Apache in the Louisiana third-party action?
They 100% could have. I'm so glad you raised that. Both parties could have brought their actions. They could have, we could have asserted our indemnity claim, and Wagner could have asserted his declaratory judgment claim in that third-party action. That litigation is terminated. Now it's over. But at the time, Wagner definitely had that option, which is something that they overlook in their briefs. So both parties had that option. Now, because there is a valid and binding arbitration agreement, and the question is related to scope, this court said in Prudential Securities that a court should not deny arbitration unless it can be said with positive assurance that this arbitration clause is not susceptible to an interpretation which would cover the dispute at issue. And this court also, was there a question?
There is, but go ahead. I'll ask after you finish.
Oh, and this court also said in INRI Next Financial Group that those exceptions, any exceptions to the scope of an arbitration clause, have to be construed narrowly. Go ahead, Your Honor, Justice Guzman.
So I was going to ask about the CA's delving into the merits or the substance of the dispute to reach its conclusion. Do you think it improperly did so? It seems like it didn't. I wanted to use the word stick to the text, but I'm trying to find a more artful way to say that. But it seems it went outside of the text to resolve the dispute by looking at the substance or the merits.
I understand your question, Your Honor. No, I don't think it did do that. What the Court of Appeals did was it looked at the overall language of the agreement to read the arbitration clause in context of the entire agreement, which is what this court instructs it to do. And it wasn't saying that Apache is entitled to indemnity. That would have been the merits. What it said was indemnity was clearly something that was on the parties' minds. It also said that arbitration was a very important part of this agreement. And that is correct. As I mentioned before, the parties spent 5 single-spaced pages in this contract on procedures for arbitration, specifying that they were supposed to be done in a manner to be less expensive and more speedy than litigation. And they have a very, very broad arbitration provision. So that's what the Court of Appeals was doing. It wasn't saying that we should win on the merits. What it was saying is that the idea that the single most important continuing obligation in this contract, which is indemnity, would almost never actually be arbitrated when arbitration was so broad, just didn't make sense. And
if we, Ms. Robinson, if we disagree and think that the Court of Appeals improperly considered the merits or the substance of the dispute, what does that do to your argument?
It doesn't change anything, Your Honor, because you can just read this arbitration clause and not worry about what the indemnity provisions are. Those, you don't need those. The Court of Appeals used that to buttress their conclusion that I believe they reached just reading the plain language of this clause. And that's really all you need. Because again, because this is an issue of scope, to the extent there's any doubt, then it has to be resolved in favor of arbitration. And we have proffered a reading of this sentence that is completely reasonable, uses all the language, doesn't add any language, and follows the rules of grammar. And because that is a reasonable interpretation of this sentence, that requires this case to be compelled to arbitration. Now, the dispute about the non-signatories, in this case, well, this court has recognized in Kellogg, Brown, and Root that there are multiple ways that non-signatories can be held to be compelled to arbitration. And 2 of those are assumption and incorporation by reference. Now, either one of those would be sufficient, but in this case, we have both. As I think you guys recognize, the court recognizes, and as I think Mr. Keltner agrees, the purchase and sale agreement and the Apache assignment were part of a single transaction. Both documents explicitly refer to the others. Signing the Apache assignment was a condition precedent to closing of the purchase and sale agreement. And they were signed by the same parties as one transaction. The Apache assignment explicitly refers to and incorporates by reference all the terms and conditions of the purchase and sale agreement. The day after the parties signed the Apache assignment, then Wagner Oil Company transferred its assets versus the Wagner Oil Company assignment. And if you look at page 8 of the bench book, you'll see that in that assignment, the non-signatories agreed that that assignment was subject to all the terms, provisions, and conditions contained in the Apache assignment. So it incorporates the Apache assignment by reference. That alone could be enough. But then they also say they assume and agree to be bound by and perform their proportionate parts of all obligations imposed upon the assigner by the Apache assignment. So what Wagner would like you to see is to insert the word divisible before the word obligations, but that's not what appears here. They agree that it's subject to all the terms and conditions and provisions in the Apache assignment. And they agree that they are going to assume all of those obligations. One of those obligations is the obligation to arbitrate. And so arbitration, the non-signatories are just as subject to arbitration as they are to, as Wagner Oil Company is. And again, I believe that in the briefing, Wagner Oil Company sometimes confuses the issues of scope versus the existence of an arbitration agreement. And it cites a lot of cases that talk about how you have to be clear that these disputes have to be arbitrated. Well, those cases typically deal with whether or not there's an actual enforceable arbitration agreement. As between Wagner Oil Company and Apache, there's no dispute. The parties don't dispute there is. And again, as to the non-signatories, the only relevant consideration is whether they assumed it and they incorporated it by reference. They did both. Either one would be enough. So then once you move past that, you understand that there's an enforceable arbitration agreement. The relevant question is scope, which is what we spent all that time discussing that sentence. And that has to be, if there's any ambiguity, has to be determined in favor of arbitration. Now, if subject to the court's questions, I would like to touch on the issue of venue. What Apache did was it filed an arbitration agreement, an arbitration between the parties in Houston, Texas, which is what the agreement specifies. It says there's a mandatory venue provision in Houston, Texas for any arbitration. And then after the parties had selected their arbitrators, what Wagner did was file its action, its declaratory judgment action in Tarrant County. And then when Apache answered the complaint, Wagner then said, well, now you've done an initial application for arbitration, and therefore venue is fixed here. This court cannot and should not hold that a person who wants to avoid arbitration in an arbitration clause that has a mandatory venue provision can make that mandatory venue provision meaningless by filing its action anywhere it wants, because it's putting the other party in an untenable position. Apache had to answer that lawsuit. It had to file a motion to transfer venue, otherwise that argument would have been waived. It had to answer that lawsuit, otherwise it could have been found to be in default. It had to demand arbitration because otherwise it would be engaging in the litigation process. It could waive its arbitration claim. What Wagner had done is it asked the court to find that there was no valid arbitration agreement. That is an initial application. And that initial application under the CPRC had to be filed in the place where the parties had venue, or it had to be filed in the place where the opposing party was located, which is also in Houston. Now, it's funny because Mr. Searcy, who represents Wagner in this case, made that exact same argument that Apache is making today, that an action to invalidate an arbitration provision must be filed in the place where that venue is because that is an initial application. He made that argument in INRI CBIF Limited Partnership in this court, which is number 16200 in 2016. He was right then. He's changed his mind now. But the truth is, an action that is seeking to find that an arbitration is invalid, an arbitration clause is invalid, is and must be the initial application. Otherwise, this court will hold that those venue provisions have absolutely no meaning. Now, in the interest of judicial efficiency—
Are you arguing that the Court of Appeals erred by not transferring the case to Harris County?
The case, yes, Your Honor. The case should have been transferred to Harris County.
Did you need to file a cross petition on that?
So, no, Your Honor. We had filed a mandamus petition relating to the venue error, and the Court of Appeals denied that venue petition, and then it addressed it in its briefing, in its opinion. And so under the traps, you know, if both parties have briefed it in the Court of Appeals and the Court of Appeals doesn't reach it, it can still be reached by this court. But to be very clear, we are not asking this as a reason to reverse the trial court's order, because we believe that this court can and should reach the arbitration issue. What we are asking is for the court to transfer this going forward to Harris County, because there will be further litigation involving this lawsuit. And it should be in the mandatory venue that the parties set when they bargained for and negotiated a mandatory venue in Harris County. So that's where it should go forward, and we're asking this court to transfer it for future purposes. So in short, subject to this court's question, further questions.
Done that? where it goes forward and you get the benefit of the judgment in the wrong, of the order in the wrong venue, and then it goes to the other venue?
I haven't been able to find a one with these specific facts, Your Honor, but this court frequently does take up issues that are pure issues of law. There's no further fact development that would need to take place at the trial court. And so this court frequently does take up issues that are fully briefed, and both sides have briefed this, pure issues of law. And if this case goes back down to Tarrant County, there will be, even if this court compels arbitration, which it should, there will be further actions involving that. There's going to be, a motion to enforce the arbitration award and so forth. And the mandatory venue for that is and should be in Houston, Texas. So in order to prevent further delay, and I have to say this case was filed, we started our arbitration 3 years ago, and under the provisions, it was supposed to be ordered over in 6 months. And it would be a tremendous waste of additional time if the parties had to come back up and fight over this venue provision again, when we've already spent 3 years arguing about the arbitration. So that's why we're just asking for that relief, Your Honor. So in short, if there's no other questions, we would just ask the court to affirm the Court of Appeals decision compelling arbitration. Arbitration should be compelled in this case. And we further ask that on remand that the case be transferred to Houston, to Harris County, so that future disputes relating to arbitration can be held in the parties bargained for in negotiated venue of Houston, Texas. Are there any further questions?
Any other questions? Thank you, Ms. Robinson.
Thank you.
Mr. Keltner, I believe you have 5 minutes.
Your Honor, let me answer one question about the venue issue up front. The issue is it's not appealed here, which is interesting by cross petition. On the other hand, let me tell you what happened. When arbitrators were appointed, we objected and basically reserved our rights, as the Court of Appeals opinion specifically points out. We were very careful under Chapter 171 not to do certain things. We were very careful not to join any issue on arbitration, neither to compel nor stay or set the rules. We read Chapter 171, 021 through 024 and then 096 very carefully and decided not to do that. And we just want an interpretation of the document where it was executed and actually negotiated. What subsequently happened is they came in and they did more than answer. What they did is file a motion to compel, which under 021 of Chapter 171 was the initial application. So in that issue, that is actually what happened. Now, let me go back to a couple of things. What you heard Apache argue is they are not adding any language. They are applying grammatically what happened. And that is, everything's fine. The agreement clearly says what they say it does, but it doesn't. If you look in our handout 2, or tab 2 in the handout, if the arbitration carve out, the second sentence says what they want it to say, it would say what tab 2 does. And that is, if you file a cross action, you're not subject to mandatory arbitration. That is not what the agreement says. It shall be entitled. And I want to make sure that everyone on the court understands this. We are not claiming that you lose it or use it or lose it. They could bring that claim. In answer to the question of cross claims, you could not bring that in indemnity action actually in Louisiana because it was not ripe at that point. The duty to defend might have been, but the indemnity action would not have been ripe till after that case was decided. This is, go to one other thing about the assignment. In their brief, they say one thing that candidly concerned me. They said that, well, we pointed out that they had not initially asked the non-signatory beneficiaries to undertake the indemnity obligation, and they didn't. They said, well, we didn't even know it had been assigned. And I thought, if that's true, I've got to tell the court that. But we're right. They're mistaken. What happened was, if you look at 11.5 of the agreement, the assignment, everybody assumed that this would be assigned on both sides. And in fact, there were consequences of that. But what it said was, you're going to look to one party for performance, and that was to Wagner Oil. That's 11.5. Second issue is, first off, the assignment was filed of record in Louisiana, which would be enough. And then what happened was, when the plaintiffs filed in Louisiana against both Wagner and Apache, they included the assignments. So before the demand for indemnification was made, Apache certainly did know about the assignments, and I wanted to clear that up. Again, we think their interpretation is not reasonable because it changes what the parties agreed to be permissive to being mandatory. And tab 2 demonstrates that issue. If they wanted to,
if we read that section as saying you've got a couple of options, that one is arbitration, which is not mandatory, but it's allowed, and the other is to assert the claims in the third party action, then isn't the option to assert the claims not in the third party action sort of an unstated third option? Is that the way that you're viewing it?
yes, here's what happens. If there's a third party action, there is no mandatory arbitration. You can't assert your claims as cross claims. You could assert them otherwise. And in first party actions as well. And that's what we think the phrase means.
If it's unstated, then shouldn't we apply the presumption?
As to the issue of whether there could be no first party claim,
As to the
first party claim for indemnity.
As to the issue of whether you can file your cross claim otherwise than in a third party action or in arbitration.
Your Honor, I would not go that far. I would just say that if you can't do, if there is not mandatory arbitration, you certainly have any other relief to which Apache might be entitled, and that could be filing it in a separate action.
Any other questions? Thank you, Mr. Keltner. The case is submitted and the court will take a brief recess.